The default among Texas banks
Mm-hmm.
now is if two people are on a bank account, that they create the account as a joint account with right of survivorship. Often that's abbreviated JTROS, joint account with right of survivorship. And that means that money is going to pass outside of probate.
Mm-hmm.
And it's a very dangerous thing. You need to be very careful and mindful if you put other people on your bank account, because the default form that that bank officer is going to have you sign is going to create a right of survivorship account, meaning that that money is going to go solely to the person who survives of the two people on the bank account, regardless of what your will says. And so it's very common for someone to put a child, for example, on their bank accounts to say, well, if I'm not able, my child will be able to write checks for me. That's fine if we're dealing with a relatively small amount of money on the estate. But if you have 3 children, you've in effect given a gift to one child, and the other children don't have anything. And the will won't fix that unless there are enough assets in the estate to rebalance that, and the will specifically directs that. And most wills don't fix that problem. So be very mindful when you create a joint bank account that you know that this is not changing your overall estate plan.
Mm-hmm.
If I had $10,000 in the bank,
Mm-hmm.
and I put my child on the bank account with me, I haven't made a gift of money to my child. But from the bank's point of view, we're both now co-owners of that account. If my child steals my money and runs off, the bank's not going to help me out. I can't go get mad at the bank. So, and it is the survivor of the two of us that gets that money. So it's a convenience factor. It's often a good thing to handle with one relatively small bank account to make sure that your bills can be paid promptly after you pass away. Funeral expenses can be paid, for example. But to try to handle most of your money or large savings account and brokerage accounts in that manner is usually not advised. And if you want to do that, you should talk to your whoever drafted your will or whoever is drafting your will and make sure that you have worked all of that together.